So the Department of Justice, Attorney General Bondi, 25 individual states, and now several 2A organizations have united to back the struggle against statewide concealed carry prohibitions in those regulations and challenges currently sitting before the Supreme Court. Let's examine what's occurring in this pivotal challenge. Now, before we jump into this video, if you guys want to support the channel for free, please think about subscribing to the channel. That naturally helps the channel to expand. So I just want to express my gratitude to you folks for all of your backing. And then also simply leave a positive remark down below. You know that assists in telling the algorithm that you folks support this category of 2A content. And distribute this video to other firearm owners that you'd believe would perhaps value this type of 2A information. As I stated in the introduction, in this video I have some updates for everyone in regions like New York, California, Hawaii, and others who are presently facing statewide attempts to prohibit concealed carry. Many of you folks are conscious like me in California. We are confronting concealed carry prohibitions despite the fact the Supreme Court delivered the Bruin ruling. Currently, there exists a case before the Supreme Court on emergency grounds, and that is the Wolford versus Lopez matter. And it's disputing that kind of statewide concealed carry ban which was enacted in direct opposition to Bruin. This dispute centers around a preliminary injunction and the Ninth Circuit determining that a state could implement a catch-all public property restriction. And all of that was accomplished despite the fact that Supreme Court had previously declared that a state needed to shift away from may issue permits to shall issue permits. But states like Hawaii, California, New Jersey, New York, and others decided that no, they weren't going to adhere to that, and they were still planning to prohibit concealed carry in the entire region. Recently, to the amazement of many, the DOJ and AG Bondi and the Trump administration moved forward in this litigation, and they chose to back this challenge in the Supreme Court. They lately submitted an amicus brief to the Supreme Court contending that it's finally time for the Supreme Court to assess this carry prohibition on an emergency basis, and they needed to invalidate all of this lower court defiance. Also, they included a mention that they desire the Supreme Court to potentially examine other matters like rifle prohibitions and magazine restrictions, which was intriguing that they incorporated that in this brief as well. This endeavor has now been joined by 25 pro-2A states and additional Second Amendment groups like NAGR, GOA, CRPA, and now A&JRPC. And all of those organizations are combining with the 25 states and the Trump administration to assert that it's time finally for the Supreme Court to intervene on emergency grounds and invalidate this lower court rebellion. Now, this litigation is a dispute to Hawaii's new statutes on concealed carry that they approved in reaction to Bruin. This legislation, like others, attempted to insert more limitations to concealed carry and establish a default rule where people can carry firearms on private property only if the proprietor of that property provides explicit permission for individuals to do so. The consequence of this law is that even if someone obtains a permit, which is extremely difficult to do in Hawaii, but even if you acquire a permit, it's almost worthless because the state forbids concealed carry at almost every location. Because of this, the plaintiffs, along with 2 organizations in the Trump administration, are now requesting for the Supreme Court to overturn this law. On examination, a district court issued a TTRO, also recognized as a temporary restraining order, which was then subsequently transformed to a preliminary injunction. Now, in that verdict, the district court blocked the private property rule as likely a violation of the Second Amendment and inconsistent with what the Supreme Court expressed in Bruin. This matter then proceeded to the Ninth Circuit on review because Hawaii contested that, and eventually it was evaluated by the Ninth Circuit along with the California carry ban case. On assessment, the Ninth Circuit maintained the catch-all property ban in Hawaii and reversed the injunction that was ordered by the lower court, so they aligned with the state of Hawaii. The Ninth Circuit relied on earlier restrictions on hunting on private property to endorse this statewide concealed carry ban that Hawaii implemented. After that, the plaintiffs then asked for the Ninth Circuit en banc to reconsider this case, but that was rejected by the Ninth Circuit en banc. They resolved to not inspect this case. Now there were some objections in that denial. Judge Van Dyke, along with other judges in the Ninth Circuit, disagreed, and they criticized their colleagues in the Ninth Circuit for once again handling the Second Amendment like a second-class right. That has guided this case to now pursue emergency Supreme Court review. And the plaintiffs here are asking for the Supreme Court to step in on an emergency foundation and strike down what the Ninth Circuit proclaimed. Now, this litigation theoretically had a long chance of obtaining Supreme Court review, since the general track history of the Supreme Court is that when it concerns 2A cases, they do not get involved on interlocutory decisions. They do not prefer the preliminary injunction phase or the TRO stage matters. But now you have the United States government, A.G. Bondi, and through the DOJ they have intervened in support of the plaintiffs and the request for emergency assessment of this case. Now, even greater, the Trump administration has been joined by 25 states and multiple 2A organizations who are also demanding for the Supreme Court to finally take action on this topic. In the recent amicus brief, the United States government declares that the near-complete prohibition is plainly inconsistent with Bruin and the long history underlying it. Bruin acknowledged that an ordinary law-abiding citizen has a general entitlement to publicly carry arms for self-defense. Just as states may not restrict the right to those who show a special need for self-defense, states may not constrain the right to those who aimlessly wander the streets. One of the fascinating things also within this brief by the Trump administration was that the government here pressed the Supreme Court to accept the case on a preliminary injunction stage despite the court's track record. This is significant because we have observed the Supreme Court has generally avoided all these interlocutory cases like I mentioned. But here you have the Trump administration informing the court that they should take this one and this one is distinct. These arguments have been echoed in the documents also filed by the 25 states and all of those Second Amendment organizations. The brief of the 25 states in backing of this petition states that Bruin reassured law-abiding gun owners that the Second Amendment was no longer a second-class privilege. But lower courts have largely failed to follow through on that promise, resorting to manipulative en-banc practices, ahistorical interpretations of covered arms, and improperly calibrating the level of generality for Bruin's inquiry. These incursions on citizens' public carry rights will continue to grow unless the court interferes. They go on to declare in their brief that each of these ploys chips away at the scope of citizens' Second Amendment rights, and if unchecked by this court, Bruin's reassurance will be little more than an empty guarantee. And now organizations like CRPA, DOJ, NAGR, and A&JRPC have also submitted a brief in support of this litigation. They state that if this court denies certiorari, there will be no meaningful ability to carry in Hawaii for at least 7 years while the litigation continues. The Ninth Circuit's animosity towards the Second Amendment is well documented, having recorded an undefeated 50-0 record of upholding gun laws before Bruin. Bruin altered nothing in the Ninth Circuit, and the Wolford ruling is not even the most recent example of the court giving a judicial middle finger to this court. So brazen has the Ninth Circuit's resistance become that even when the Wolford panel disgracefully relied on a racist law to justify Hawaii's law, the Ninth Circuit refused to fix it, denying en banc review over the dissents of 8 judges. They state that, unfortunately, the Ninth Circuit has been encouraged by this court's hesitation to take Second Amendment cases in an interlocutory posture. But if there was ever the perfect case to which to make an exception to this court's preference of not deciding interlocutory matters, it would be this particular one. A&JRPC, in support of this matter, states that immediately following the court's Bruin ruling, the very states whose unconstitutional carry prohibitions had just been stricken raged in open resistance of this court. Importantly, Hawaii's law at issue in the petition is not alone in its total affront to the fundamental right to carry recognized in Bruin. Rather, it is a part of a comprehensive and synchronized assault on this court's historic ruling. In rapid succession, 5 states, New York, New Jersey, Maryland, Hawaii, and California, enacted Bruin attack laws which clearly sought to nullify this court's ruling in Bruin and the basic right to carry a handgun in public for self-defense. The states are simply not receiving the message, and until the court squarely takes up this issue, the defiance will persist. So uniformly, you have the Trump administration, 25 pro-2A states, and multiple 2A groups who are conveying the same message to the Supreme Court. Lower courts, they are claiming, are openly defying what the Supreme Court stated in Bruin. You have states like California, New York, Hawaii, and others who are openly resisting what the Supreme Court expressed in Bruin. And they have no worry of the Supreme Court stepping in at this moment. They are not taking Bruin seriously. And until the court chooses to step in on an emergency foundation like in this case, those lower courts in those states will continue to do the identical thing, and they will continue to handle the Second Amendment like a second-class right. Currently, Hawaii's answer is due on June 4th, and then there will be a final reply also by the petitioners. But the major question which remains in this litigation is if the Supreme Court will accept the message from the Trump administration, the 25 states, and all these organizations and the petitioners, and recognize that yes, it is finally time to step in on an emergency basis and halt all this lower court defiance, stop the state resistance, and invalidate these catch-all carry bans that were approved in direct response to Bruin. So that's what's presently happening in the critical carry ban in front of the Supreme Court. And as we gather more details, I will let you folks know. But as always, thank you all for viewing. Don't forget to like, comment, and subscribe.